323.1 describe the protections of search and seizure in the Fourth Amendment. The Fourth Amendment protects individuals from unreasonable searches and seizures by government agents, safeguarding areas where a person maintains a reasonable expectation of privacy, such as their home, person, papers, and vehicles. It establishes that warrants must be supported by probable cause, issued by a neutral magistrate, and explicitly describe the place to be searched and the items or person to be seized. 323.2 describe the legal requirements to obtain a search warrant. To obtain a valid search warrant, an officer must draft a comprehensive probable cause affidavit demonstrating a fair probability that specific evidence or contraband is located inside the targeted location. The warrant must be reviewed and signed by a neutral, detached judge, must clearly specify the address and physical description of the property, and must explicitly list the particular items law enforcement is authorized to search for and seize. 323.3 explain the exceptions to the search warrant requirement. Law enforcement may conduct a search without a warrant under several strictly defined exceptions, which are categorized based on whether probable cause is required. The first, exceptions requiring probable cause. Mobile conveyance, otherwise known as Carroll Doctrine. Exigent circumstances, destruction of evidence, fresh pursuit, or an emergency scene. Exceptions not requiring probable cause. Consent searches, vehicle inventories, administrative searches, searches incident to a lawful arrest or abandoned property in open fields. 323.4 describe the three conditions that must be met to seize contraband in plain view without a warrant. An officer may seize an item without a warrant under the plain view doctrine only if all three conditions are satisfied. The first one is the officer must be lawfully positioned in a location where they can clearly see the item. Secondly, the officer must have a lawful right of physical access to the item. And third, the incriminating character of the item must be immediately apparent as contraband or evidence of a crime. 323.5 explain when searching a mobile conveyance is legal without a warrant. Under the Carroll Doctrine, searching a mobile conveyance without a warrant is legal if an officer possesses probable cause to believe that contraband or evidence of a crime is hidden inside the vehicle. The exception is legally justified by the vehicle's inherent mobility and the reduced expectation of privacy associated with operating a vehicle on public roadways. The scope of this search extends to any part of the vehicle and any container inside it that could reasonably conceal the object of the search. 323.6 when the destruction of evidence permits a search without a warrant. Explain when the destruction of evidence permits a search without a warrant. The imminent destruction of evidence falls under exigent circumstances. If an officer possesses probable cause to believe that critical evidence of a crime is located inside a protected area and has an objective, reasonable belief that the evidence will be destroyed, altered, or removed before they can secure a search warrant, they may enter in search to secure that evidence. 323.7 explain the fresh pursuit exception to the search warrant requirement. The fresh pursuit exception applies when an officer is actively and continuously pursuing a fleeing suspect who has committed a serious offense. If the suspect enters a private residence or protected structure during the pursuit, the pursuing officers may enter the structure without a warrant to apprehend the suspect and may seize any evidence or weapons found in plain view during the arrest. 323.8. Explain how an emergency scene relates to warrantless entry. Under the emergency scene doctrine, officers may enter a private dwelling or protected area without a warrant if they reasonably believe an immediate emergency exists requiring their intervention to save lives, prevent severe injury, or render aid to an endangered person. The entry must be motivated solely by the emergency, not by a desire to search for evidence, though any contraband seen in plain view during the response can be lawfully seized. 323.9. Explain the importance of consent when conducting a warrantless search. Consent acts as an explicit waiver of a person's Fourth Amendment protections. For a consent search to be legally valid, the consent must be given voluntarily, knowingly, and intelligently, without any coercion, threats, or explicit submission to authority. Additionally, the individual giving consent must possess the actual or apparent legal authority to grant access to the specific area or property being searched. 323.10. Explain why vehicle inventory does not require a search warrant. A vehicle inventory is an administrative, non-investigative procedure designed to document the contents of a lawfully impounded vehicle. It does not require a warrant because its primary purpose is to protect the owner's property, protect the police department from false claims of theft or loss, and ensure officer safety from dangerous items. It must be conducted uniformly according to written agency policy, not as a pretext for an investigative search. 323.11. Explain why an administrative search does not require a search warrant. Administrative searches are routine inspections conducted by government regulators or officers to enforce compliance with health, safety, fire, or highly regulated licensing codes, such as inspectors of commercial gun shops, salvage yards, or venues serving alcohol. They do not require a standard criminal warrant because they serve a broad public safety purpose rather than a criminal investigative intent, and are limited in scope by specific statutes. 323.12. Explain why searching someone under arrest does not require a search warrant. A search incident to a lawful arrest is a recognized exception allowed automatically once a person is taken into custody. It does not require a warrant because it serves two immediate government interests: removing any weapons the arrestee might use to escape or harm the officer, and preventing the concealment or destruction of evidence on their person or within their immediate wingspan. 323.13. Explain how abandoned property and the open fields doctrine relate to a warrantless search. Abandoned property. When a person voluntarily discards or abandons property, such as tossing a bag while running or placing trash at the curb, they relinquish any reasonable expectation of privacy in it. Officers may search and seize the property without a warrant. Open fields doctrine. Unoccupied or undeveloped land lying outside the curtilage of a home is considered an open field. Because society does not recognize a reasonable expectation of privacy for open fields, officers may enter and search them without a warrant, even if the land is fenced or posted with no trespassing signs. 323.14. Describe the scope of searches legally permitted for a law enforcement officer. The scope of any search is strictly defined and limited by the legal justification that authorized it. For a search warrant, the scope is restricted to the specific locations and containers listed in the warrant that could reasonably contain the items being sought. For an investigative frisk, it is limited to a pat-down of outer clothing for weapons. Officers must never expand a search beyond its original legal boundaries unless they develop additional independent justification. 323.15. Describe the legal seizures under the Florida Contraband Forfeiture Act. Under the Florida Contraband Forfeiture Act, State Statute 932.70-932.706 of the Florida statutes, law enforcement may seize vessels, motor vehicles, aircraft, currency, or real property if there is a probable cause to believe the property was utilized as an instrumentality in the commission of a felony, or was acquired using the proceeds of felony criminal activity. The Act establishes formal civil procedures the agency must follow to permanently claim ownership of the seized property.